Can you guys see my slides?
Yep.
Okay, great. So hi everybody, my name is Orla Kelleher and I'm going to be talking today about whether a state's individual contributions to climate change can be accommodated within traditional legal doctrines like causation and what I call systemic rights-based climate litigation. So I essentially argue in this paper that accepting a material contribution to risk of climate harm as sufficient causation can help overcome many of the difficulties this doctrine presents in climate litigation. And I would argue that this aligns quite closely with Henry Hsu's theory of climate justice because it forces governments to at least at a minimum take responsibility for their own contribution to the problem of climate change. And I would also argue that it prevents governments from trying to extricate themselves from responsibility by, for example, pointing to their relatively small emissions on the global scale, or by pointing to other countries who are maybe not doing their part to tackle climate change either. So just trying to move forward my slide. So as a concept, very briefly, climate justice is a concept that focuses on sharing the burdens of climate change fairly. So philosophers have referred to three different kind of principles for allocating responsibility for climate change on a moral basis. So contributor, polluter pays, ability to pay, and beneficiary pays. And Henry Hsu's very useful contribution to that is that these principles tend in principle to converge upon the same states, namely wealthy developed countries, at least initially, bearing the lion's share of responsibility for tackling climate change. And I don't think it's particularly controversial to try place Ireland and the Netherlands in that category. So that normative principle or theory of climate justice is broadly reflected in the expectations and general principles and objectives of international climate law in terms of what's expected of developed countries. So concepts like common but differentiated responsibilities, equity, and developed country leadership. So I'm now going to try superimpose or to try apply some of this theory of climate justice to two judgments. So the Urgenda judgment, which was referred to briefly I think in Lee's presentation, and also the recent judgment in Climate Case Ireland, or Friends of the Irish Environment versus the Government of Ireland. So in terms of the Urgenda judgment, so for those who maybe are not aware of it, in 2013, Urgenda, NGO in the Netherlands, initiated a class action against the Dutch government, alleging that the Dutch government emissions levels were unlawful. So they sought a mandatory order to reduce emissions by 40% by 2020 compared with 1990 levels, or at a very minimum a 25% reduction. And those figures came from AR4, which was the IPCC's advice, and that had been repeatedly endorsed through the UNFCCC and Kyoto Protocol conferences of the parties. And so that advice had been repeatedly accepted by the Netherlands and by the EU as the parties had signed off on that. And so Urgenda essentially claimed that the Dutch government's climate or carbon emissions were unlawful under Dutch tort law, but also that they violated Article 2 and 8 of the Convention. So in 2015 then, the Dutch District Court accepted Urgenda's arguments and ordered at least a 25% reduction by 2020, but it based its judgment on Dutch tort law. On appeal to the Court of Appeal, that was upheld, but on the basis of ECHR law. So for time constraints, I'm just going to focus on a few elements from the Supreme Court's judgment, which was handed down about this time last year. So the Supreme Court again upheld that judgment of the lower courts, again on human rights grounds. The Supreme Court stressed that states that the Dutch state had a positive obligation under Article 2 and 8 of the ECHR to take preventative measures to mitigate a danger, so in this case climate harm, where there's a real known risk of real and immediate risk to people's lives and welfare. So that was so even if the danger was in some way uncertain, even if that risk of environmental harm would impact a huge cohort of people, and even if that harm might not materialise for in the short term. So essentially what the Supreme Court said was that partial fault justifies partial responsibility. The Supreme Court said the fact that other countries were maybe failing to do their part, or that Dutch emissions were relatively small on the global scale, wasn't really an excuse for the Netherlands to fail to perform its own individual obligations, as otherwise every state would be able to extricate itself from responsibility, and there wouldn't be effective remedies for climate litigants. So the Supreme Court also found that the government hadn't really explained why it should be entitled to an emissions reduction target less than that which had been widely agreed via the COP decisions, and placed particular emphasis on the Netherlands' very high per capita emissions. So I would argue that this approach aligns very closely with that concept of climate justice I spoke about earlier. The Supreme Court in particular emphasised the Netherlands' special position as a wealthy country that had accrued much wealth from fossil fuel exploitation, and I would argue that that aligns quite closely with this concept of climate justice. So the second case I want to talk about then is the Friends of the Irish Environment case. So in that case, FIE, which is an environmental NGO, was challenging by way of a judicial review the government's approval of the National Mitigation Plan, which was the Irish government's for climate change, and was challenging on the basis of being ultra vires, and that also breached Article 2 and 8 of the Convention and constitutional rights. So FIE placed particular reliance on the fact that emissions were actually going to rise over the lifetime of the plan, but and again relied on that same scientific evidence as their agenda about the Irish government, like the Dutch government, having repeatedly endorsed that AR4 advice. But the High Court found that the government enjoyed a lot of discretion in the area of climate under the Act, and that as a result the court really wasn't in a position to be second guessing the government. So the High Court found, without really much elaboration, that the approval of a national mitigation plan didn't actually breach constitutional rights or put them at risk. In other words, the High Court said there was no real causal link between the Irish government's approval of this plan and a breach of rights. And I would argue that the problem with that line of analysis is that it fails to elaborate on how NMP that was allowing emissions to rise could be considered, whether that essentially in allowing it to allow emissions to rise, that it created a risk of adverse climate impacts, and whether that could be tantamount to constitutional rights breach. So on the alleged ECH4 rights breach, the High Court refused to attach any weight to the agenda judgment on the basis that the Strasbourg Court hadn't yet ruled on the matter of the application of the Convention to climate harm. And in doing so, I would argue the High Court closed itself off from a very pertinent line of analysis in our agenda that had extrapolated principles from the Strasbourg Court on Articles 2 and 8 and environmental harm, and essentially had concluded that contributing to a real and immediate risk of harm, that was in itself amounted to a violation of rights. So I would argue that the High Court's analysis of that rights dimension of the case is particularly difficult to reconcile with the concept of climate justice. The judgment essentially allowed a developed country that should have been taking mitigation, leading the way on mitigation measures, to evade responsibility for actually growing its emissions based on the wide discretion of the executive, but also on an unwillingness to actually look behind the climate plan itself and scrutinise how it might impact on rights. On appeal to the Supreme Court did in fact quash the National Mitigation Plan, but did it on very narrow grounds, on statutory grounds. So the Supreme Court based its judgment on the statutory obligation under the 2015 Act to specify how the government was planning to achieve its 2050 target. So the Supreme Court dismissed the constitutional and human rights aspects of the case on procedural grounds. So basically, Friends of the Irish Environment as an NGO didn't have standing to litigate personal individual rights. So in conclusion, I would argue that, I suppose, whether the Irish courts would be willing in future to accept this idea of a material contribution to risk of harm as being enough to ground an alleged rights violation in future climate cases, it remains quite uncertain in the wake of the recent climate case judgment. Even though the Supreme Court, skirted around these questions, it did kind of maybe suggest that it might be open in future to more environmental constitutional arguments. And I would argue that there's reasons at least to believe that the Irish courts would be willing to entertain this line of argument that material contribution to risk should be enough. So I think there's maybe two reasons for that. The first is that there are currently two climate cases that have been filed with the European Court of Human Rights in Strasbourg. I would argue that if these are accepted and if they're successful, the Irish courts will no longer be able to argue that it can't rule on this matter because the Strasbourg courts haven't yet decided if the convention can be applied to climate change. And the second, I would argue, is that if the superior courts are in future willing to engage with constitutional and human rights arguments in the future in climate cases, the Supreme Court could draw on its existing jurisprudence in the area of causation in toxic tort cases. So, for example, it has been accepted on public policy grounds in common law jurisdictions that a material contribution to risk as a test could satisfy a causation requirement for liability in toxic torts where you have an indivisible injury, for example, in mesothelioma cases. And I would argue that there is certainly strong policy grounds here in the context of climate change, stemming from both the urgency of the crisis, but also the complexity of the causes.
Sorry, Orla, you're just coming on time there.
Oh yeah, no problem.
Apologies.
I have one last sentence to wrap up, but I would say if that were the case, that kind of approach would align a lot more closely with the concept of climate justice. So that's it for me. Thanks very much for listening.